How to start a will contest. The most important requirement, and you may have this come up when clients come in and they complain about a will, is that they have to have standing to object. That is, that they have an interest that would be affected by the will being admitted to probate and being probated. And that is that they would have received a benefit from it. You frequently will get people who come in, maybe a sister or a brother of the decedent, who are not in a position to take because there are children, and they complain that the decedent was incapacitated, was taken advantage of. But if they don't have a stake in what would happen either under the will or if the will was set aside, then they don't have standing to object. If the client who has come in has standing, then there are two methods that can be used to begin a proceeding. The first is to file what's called a caveat with the surrogate. Caveat is something that the only times I've had to deal with it have been where the client has already filed a caveat and the surrogate said, well, now you have to do something more, and the client didn't know what to do. The other way, which is the route that I follow, is to file a proceeding directly in the Superior Court Chancery Division, probate part, after the will has been admitted to probate. Filing a caveat will prevent the surrogate from admitting a will to probate or indeed taking any further action, because the rules provide that the surrogate is unable to act whenever there is any contest, any dispute over the admission of a will, over the terms of a will, over the enforcement of a will. He has to refer that to the Superior Court probate part. And so that, even if you file a caveat, that will only stop things from happening. If you want the proceeding to go forward, or if the proponent of the will wants it to go forward, they must commence a suit in the Superior Court to litigate the dispute. And that is where the will contest will lie.